The next case that is set for hearing this morning is State of Ohio versus Darlene Messer, and that is case number 28750. The appellee waived on this. So Attorney Connolly, you will have 15 minutes to present your argument. We've read the briefs and we're ready to proceed.
Thank you, Your Honor. Good morning. For the record, I am Attorney Mike Conway, and I do represent the appellant Darlene Messer. The record in this case shows that my client was convicted of theft offense, revised code 2913.0281, as the charge where she, on or about the 15th of September 2016, allegedly took items from Kohl's department store in Macedonia that were worth between $1,000 and $7,000. The case was tried. When the jury went to deliberate, the jury was out for about 4 hours, and they reported they were hung. To decide this case, or shame on you type charge was given, and my client was convicted about 10 minutes later. The fact of the matter is that in getting that conviction, the government relied on a lot of conjecture. The situation was that my client was shopping at Kohl's. She had a shopping cart full of merchandise, and the peculiar thing about the merchandise is that there were no visible price tags on them. There were UPC barcodes. And so she had a full shopping cart of items, plain sight.
She had a bra on, right?
She did have a bra on. I'll get to that in a minute, Judge. But she had these items and checked some of them, bought some of them. She got a cell phone call from me. I'm her lawyer in a civil case that this court previously reviewed. That's now on appeal to the Ohio Supreme Court. And she went past a checkout counter area to sit on a bench before the store exit door, outside exit doors, to sit down to call me. And as she was turning around, a security loss prevention manager grabbed her and took her into custody. The story from the store is that through Melinda Morgan, the loss prevention officer, is that my client was followed on videotape, and she was acting the way a shoplifter would act. However, there's no expert witness testimony or any psychiatric testimony to establish anything besides an opinion that she's acting like a shoplifter, when in fact all she did was take her cart outside a point of sale area to sit down and call me, her attorney. And she never even touched an outside exit door. And this was all videotaped, and the jury saw this and shows her rapidly turning, and the witness testimony, as I briefed, agrees that she was turning to sit on a bench away from the other loss prevention officer, Joe Zalia. Now,
Counsel, before you go on, I just want to make sure I understand the facts correctly. I think I understand what you're saying. She went through like the detectors, but then there's an area where you could sit before you exit the store. I don't have any problem with that. But my understanding is, and correct me if I'm wrong, that she had, the state said $1,600 worth of merchandise that was actually in a bag.
well, the fact of the matter is that whether or not that's true, I think that's common for, I think the testimony was that that's not unusual, that people will do that. They'll put stuff, they'll manage their items so they can carry them to checkout, because some things they want to segregate and get price checks on, other things they don't. But the fact of the matter is, what I really have a problem with is the evidence in this case is that they're inferring a mental state from conduct that does not show she attempted to leave the store with merchandise. I don't think there's concurrence of a guilty act and a guilty mind.
Well, but that bag could be circumstantial evidence. Because
Well,
she paid for one item.
Let's say that, I mean, even if that were true, Your Honor, the fact of the matter is the defendant claimed that the evidence of the theft is a violation of Kohl's store policy, which is you can't take stuff beyond a certain price checkpoint or a checkout sale point. But there's no signs or anything telling customers you can't go beyond this point without buying something or paying for something. The security towers that set off alarms didn't go off either. That's been admitted in the record. There would be nothing there to tell my client you can't go through that door and sit on those benches, as the state's witnesses agreed they're there for the customers to sit on.
But isn't that kind of common sense? I mean, because that's the whole point, like you said, it's the security tower. That would be like saying you're in the library and you take a book out and you go outside to read it or something.
Well, Your Honor, that, whether or not it's common sense, that's not a substitute for proof beyond a reasonable doubt. They had to prove every element of this case with evidence of guilt beyond a reasonable doubt. And they did not show she tried to leave the store. They admitted she was turning to sit on a bench to call on a cell phone. The email I sent her telling her to call me was admitted into the evidence. There's no evidence of the price of any of the items, which is a big glaring problem for them, because Exhibit 3 is this inventory they use to establish the price of the items alleged taken, but unfortunately that was a hearsay document. That was not a record kept in the ordinary course of business. And they did not produce the actual items alleged taken. There's no way for a jury to really know what the price of any of these things were. So, and there was no charge of a lesser included offense where the jury could choose to convict her of something lesser than the theft charge under 29-1302A1. So they did not prove the price range was actually between $1,000 and $7,000. That's hearsay. It's unsubstantiated. The other point I want to call into question is that the police officer who testified in this case, Kyle Resch, called my client a criminal from the witness stand. That really is hard to overcome. When a police officer gets on a witness stand and says, "I've seen the videotape, your client's a criminal," that's pretty hard for a jury to get past. In addition, the accuser in this case was making the argument that it was Mr. Zalia was making the argument that the evidence of the crime is proved by the fact that my client was in the exit door area of the store. An objection was made, and the judge sustained that objection. But when I raised the same kind of argument on Rule 29 motion, the motion was overruled. I said you can't prove this case by showing just because, in so many words, just because she was out where this bench area was, that's the same thing as her trying to leave the store with stolen goods. That's the exact same argument that I objected to the other side trying to make during the trial. And the court sustained my objection but wouldn't grant the Rule 29 motion after the sum and substance of the state's case was based on the same theory, that my client was passed a price or a store point of sale, and therefore with goods, so therefore she must be a thief. I think that's too far of a stretch.
Wasn't there other evidence the court could have considered there as to the intent to deprive? And that's your argument here, isn't there? That there's no intent to deprive.
There's no guilty mental state, Judge. She was in a place she had a right to be inside the cold store as evidence.
Inside or outside?
Inside.
Doesn't really matter, does it? If there's intent to deprive, you don't need to be outside the store.
Well, that's the thing, Your Honor. I don't believe they proved there was an intent to deprive, because it was like, let's say the door, there's two doors where your bench is the outside door, here's the interior door, and then there's a bench for customers to sit on right here, and then the checkout counter's right here. Now, if Kohl's says you can go sit on that bench, and there's no sign saying don't walk past this point with merchandise, they're asking my client to be a mind reader and say, what's your guys' policy on shopping here? If I walk past there and sit on your bench, I'm now a shoplifter. They're putting the burden on the shoppers to figure out what Kohl's wants. Then Kohl's says the violation of its store policy is why we took her into custody and said she's a shoplifter. I don't think that's enough evidence of proof beyond a reasonable doubt to show guilt of a theft offense. Had they waited for another minute or so to see what she was going to do, I may not be standing here making this argument. But there's no evidence, and if there's no evidence, there's no evidence. And the conviction should be thrown out.
I'm sorry, what about Judge Theodosio's, I can't even say your name, Theodosio's original question about the bra that she had on?
Okay. My client had a bra on because she was checking out the bra to, I guess, to see if she liked the bra, and she got distracted with my phone call. And either way, I'm sorry, Judge.
When did the phone call come in? Was she still in the...
Well, it was while she was shopping.
Right, but
After she was after she was in the store area. Should I describe this? There's more than one place to pay for stuff inside of Kohl's. Apparently, there's an area near the dressing rooms, customer service area, and then there's an area by the exterior doors. And the video shows her looking at her cell phone. And the video shows her walking to the bench, and right as she's doing this to sit down, Joe grabs her and takes her into custody, and that's it. So I think watching that, there's a reasonable doubt.
But what I'm getting at is that the cell phone call come in while she was in the fitting room?
My recollection is a cell phone call came in before she went to the store, but she retrieved it while she was in the store. Apparently, her phone told her the call had come in after I placed the call. And that's what one of the exhibits indicates, but it cannot be disputed. She was on the phone and was picking up, doing this to call me back the minute that Joe Zalia put his hands on her.
Right, but she's walking around the store wearing a Kohl's bra under her clothing.
I don't know that it wasn't, you could see it on the video. You could see the bra on the video. She did not have it was not like she was wearing a blazer and it was all buttoned up. She was wearing a shirt where you could see the bra. I mean, everything was in plain sight. Okay, I mean, you could see the bra straps because I think she had some kind of it was summer clothes she was wearing. So there's not like you could say, okay, she's trying to hide that. I mean, that was all in plain sight.
You could see the price tag?
I believe you could. I'd have to look at that again. My memory says, yeah, you could see that. But even if you couldn't, the fact is that bra never left the store. And the fact of the matter is, if they thought she was stealing the bra, why didn't they nab her inside the store and just say, how come you're wearing a bra underneath your clothing? Apparently customers do that all the time. I believe that's what Morgan testified to in so many words. The bottom line is, without someone leaving that store with merchandise, being in an area they're not allowed to be in with merchandise, you've got this reasonable doubt. Okay, it may sound like, well, it's common sense that if you're acting the way this woman acts, she's up to no good. Well, even if she had intent to be up to no good, the fact is the crime was never consummated. There was never a guilty act because she never actually stole anything. Stuff never left the store. And if the only evidence of criminal intent is her conduct, which is the case, the evidence of the conduct isn't enough to infer guilt. So I think that this case should be reversed and the conviction vacated. Worst comes to worst, I suppose I could live with a new trial, but I would respectfully request that the conviction be vacated. If there's no other questions, that's really sum and substance of my appeal.
All right, thank you, Attorney Conway, for your presentation today. The court will take the matter under advisement and issue its decision in due course. Of course, you will receive a copy in the mail of the court's decision on the day it's released. You can also check the Supreme Court's website. You know, they're posted there as well. So again, thank you for your argument.
Thank you, Your Honor.